I request Mr. Rakesh Kumar Khanna, President, Supreme Court Bar Association, and Mr. Jiten Mohan Sharma, Vice President, Supreme Court Bar Association, to kindly escort Honorable Mr. Justice Ranjan Gogoi, Honorable the Chief Justice of India, Honorable Mr. Justice A.K. Sikri, Learned Attorney General for India, Mr. K.K. Venugopal, Learned Additional Solicitor General, Ms. Madhavi Divan, and Mr. Arvind P.Datar to the dais. I request Mr. Rakesh Kumar Khanna ji, President, Supreme Court Bar Association, to give his welcome address.
Honorable the Chief Justice of India, Honorable Mr. Justice Ranjan Gogoi, Honorable Mr. Justice A.K. Sikri, Judge, Supreme Court of India, Learned Attorney General for India, Mr. K.K. Venugopal, Mrs. Madhavi Divan, Additional Solicitor General of India, Mr. Arvind Datar, Mr. P.H. Parekh, former President and commonly known as the permanent President of the Bar, Mr. Mohan Jain, former Additional Solicitor General of India, Mr. Vikrant Yadav, Learned Secretary, Mr. Jitendra Mohan Sharma, Vice President, senior and other executive members of the Bar Association, my dear sister and brother colleagues. We are indeed very happy to start our academic pursuit with the starting of this lecture series. We are thankful to Honorable Mr. Justice Ranjan Gogoi, the Honorable Chief Justice of India, to have consented to inaugurate this series, and Mr. Justice A.K. Sikri to join on the second topic. The role of directive principles in enforcement of fundamental rights up to 80s was very, very limited. It has always been considered that directive principles are not enforceable until Justice Chinnappa Reddy in his judgment, while granting parity in pay scales, started using the role of directive principles in enforcement of equality right. Today, when the directive principles are the guiding policy for the government to frame its laws, I believe they can certainly and have been now being used as a guiding force for enforcement of fundamental rights. We'll be enlightened by His Lordship's address and the address of the Learned Attorney General and Madhavi Divanji on this topic. The second topic for the day is the economic perspectives in law. When I talked to Justice Sikri about this lecture, His Lordship himself gave this topic to us. And rightly, His Lordship pointed out that many a times when we are taking a decision, we have to keep the national economics and economics of a government or a company into mind while deciding the matters. We are grateful to Mr. Arvind Datar, who has also consented to give his talk on this topic. Not taking much of the time and standing between the lecture and all of you, I am thankful to my Lord the Chief Justice, my Lord Justice A.K. Sikri, the Learned Attorney General, Additional Solicitor General, and Mr. Arvind Datar to have consented for starting this continuing education in the bar. Thank you very much.
Thank you, sir. I request Ms. Anjali Chauhan, Member Executive, Supreme Court Bar Association, to kindly present a bouquet of flowers to Honorable the Chief Justice of India, Honorable Mr. Justice Ranjan Gogoi. I request Mr. Amrendra Kumar Singh, Member Executive, Supreme Court Bar Association, to present a bouquet of flowers to Honorable Mr. Justice A.K. Sikri. I request Ms. Sadhna Sandhu, Member Executive, Supreme Court Bar Association, to present a bouquet of flowers to Learned Attorney General for India, Mr. K.K. Venugopal. I request Ms. Shamshavish Rain to present a bouquet of flowers to Ms. Madhavi Divan, Learned Additional Solicitor General of India. I request Ms. Mukti Chaudhary, Member Executive, Supreme Court Bar Association, to present a bouquet of flowers to Mr. Arvind P.Datar, Senior Advocate. Now I request Honorable the Chief Justice of India to kindly deliver his inaugural lecture.
I am indeed honored to deliver this inaugural lecture in this very, very innovative and thought-provoking step taken by the Supreme Court Bar Association in reviving, if I may use that expression, the academic part of the bar. I am indeed honored to deliver this lecture in the presence of my esteemed colleague, Justice Sikri, the learned attorney, Mr. Venugopal, the learned Additional Solicitor General, Madam Madhavi Divan, the eminent member of the bar, Mr. P.Datar, and the office bearers of the Supreme Court Bar Association, Mr. Khanna, Mr. Yadav, Mr. Sharma, and all the learned members of the bar. I compliment the bar for choosing the topic, role of directive principles in enforcement of fundamental rights. Ladies and gentlemen, the march of civilization primarily charts the journey of human beings, mostly as a part of a race or a group or a commune on the scale of time. Across centuries, evolving modes of transport and communications, amongst other reasons, brought varied human groups or communes closer, thereby triggering and enabling a continuing exchange of thoughts and experiences across such groups and communes. Such exchange and synergy led to rapid enrichment of what may be denoted as the collective wisdom of the human race. The advent and evolution of modern nation states was primarily an outcome of such collective wisdom, as egalitarian thoughts of liberty, equality, and fraternity of all human beings came to hold the center stage in discourses across communities. In all of this, the world wars between the nations and their horrifying outcomes also injected into such collective wisdom the realization that peaceful and mutual coexistence was the only way ahead to usher in economic well-being and advancement in the quality of life on the planet. Around the same period of time, the ancient land of Bharat witnessed the march of its people through centuries of inequality and oppression, the tales of which only inspired their successive generations to aspire for the goals of equality, liberty, and fraternity of all human beings. The emergence of India as a sovereign republic from its dark age under the imperialist forces culminated in framing of the vision document, the Constitution of India. We must remind ourselves that our Constitution is not only a reflection of such enriched collective wisdom that evolved through the lives, pains, and sacrifices of our ancestors, but is also an aspirational document of our forefathers who, through their constituents, sought to lay down a charter for themselves as well as for the future generations. The emergence of nation states also witnessed recognition of state policy as an important and inseparable constituent of every such vision document. State policy would broadly refer to the nature and character of governance that was envisioned and would imply and include all government's goals that a nation state would pursue and strive for on behalf of the constituents. In our Constitution, Part 4 laid down the directive principles of state policy, which are in the nature of goals that the Indian state would seek to pursue in all its actions, especially in areas of legislation and governance. In such light, the provisions of Part 4 were meant to be dynamic and evolving as they were required to guide state policy and governance through the changing times and the varying aspirations of the Indian population. It is this view of the directive principles of state policy that needs to be remembered to understand their role in implementation of the fundamental rights. The aim of the founding fathers of the nation in including the directive principles in Part 4 was thus to lay down principles that would guide actions of the state and its agents, including the actions of the legislature and the executive. It is imperative to understand that the Constituent Assembly never meant the directive principles to remain static as they were at the inception. Realizing that implementation of the directive principles would be hugely influenced by the prevalent social, political, and economic realities of our nation, the Assembly deemed it proper to keep such principles in Part 4 non-justiciable. In other words, the Constituent Assembly laid its trust on the wisdom and the acumen of the coming generations in deciding what contemporary state action would be like, provided that no such action would be in violation of the principles laid down in Part 4. It emerges then that the directive principles of state policy would set the benchmark of state action in respect of areas covered by them, and as such, the legitimacy or otherwise of any act of the state and its agents in respect of such benchmark would certainly be weighed in the light of the principles in Part 4, even though an action seeking to enforce them simpliciter would not be maintainable. Some instances of the benchmark I may cite: the case of Hanif Qureshi, a portion of the cow slaughter prohibition legislation was upheld in deference to Article 48. In Kameshwar Singh's case, distributive justice enshrined in Article 39B and C of Part 4 were accorded priority while upholding the validity of the Bihar Land Reforms Act. State of Bombay versus Balsara, the concept of prohibition as laid down in Article 47 of Part 4 influenced the decision to uphold the validity of the Bombay prohibition law. To understand the dynamism involved, it is relevant to draw a reference to a bundle of facts that in effect brought about a paradigm shift in the role of the directive principles of state policy, more particularly in interpreting and implementing the rights in Part 3 of the Constitution. The federal polity of our republic that was envisaged at the commencement of the Constitution to be a vibrant multi-party dynamic system witnessed unprecedented upheavals in the political discourse over the decades, and that is said to have impacted legislation as well as governance goals and their implementation. This, to my mind, led to a complete standstill in some areas and directionless motion in others. Such impact appears to have dented the faith and the confidence of the people in public institutions connected with legislations and public policy, and almost as an outcome thereof, concerned citizens started bringing public-spirited plaints before the constitutional courts alleging gross violation of the constitutional mandate at several levels of governance. Such plaints eventually came to establish the remedy of public interest litigation, as such courts, namely the constitutional courts, were called upon to examine the gross violation of fundamental rights of the public in general by acts of omission and commission by the state and its agents, as well as the lack of state policy assigned thereto. In doing so, the scope of the terms life and personal liberty, as well as of various freedoms under Part Roman 3 of the Constitution, got redefined and came to be expanded on the matrix of the principles enunciated in Part 4. Some examples would be protection of ecology and environment from pollution, as enshrined in Article 48A. This got read into the expanding scope of Article 21. Right to free legal aid under Article 39A, which got read into the expanding definition of right to life and personal liberty under Article 21. The principles enunciated in Article 41 and 45 were relied upon when right to education was recognized as a fundamental right under Part Roman 3. The principle laid down in Article 47 was relied upon when the right to personal liberty was declared to include the right to good health. So on and so forth, we may carry on. Having said all that, I would like to draw your attention to another vital role that the directive principles of state policy play in implementing the fundamental rights. My emphasis being on the word implementing, as contrasted and distinguished from the word enforcing, which is the subject matter of today's lecture. On a broader framework, implementing would imply affirmative and voluntary state action in line with and with due accordance to the fundamental rights of the individual affected by such action, whereas enforcing would have as its starting point the very failure or absence of such affirmative and voluntary action on the part of the state and its agents. The very existence of fundamental rights for individuals, together with a mechanism for the enforcement by courts, would reflect that the society is governed by the rule of law, but it is also a requirement of the rule of law that the conduct of individuals, including conduct in the exercise of their fundamental freedoms, needs to be regulated by law to the extent required to harmonize it with the overriding interests of society or the public at large. It is in respect of such regulation that the directive principles of state policy play a vital role by laying down the four corners within which such affirmative and voluntary state action would have to remain, so as to uphold the fundamental rights of individuals touched by such state action. Clearly, regulated implementation of fundamental rights within the framework laid down in Part Roman 4 needs to be viewed in contradistinction with enforcement of such rights. This then could be called the fulcrum on which rests the dynamism of the role played by the directive principles of Part 4 in implementing the rights under Part Roman 3. On this note, I must add that our journey of nation building has begun on the right note. Via the implementation of fundamental rights by way of affirmative and voluntary state action, with corresponding reduction in need for the enforcement of such rights, would be a better way ahead for our republic. Ladies and gentlemen, thank you and Jai Hind. And my apologies, I won't be here for the rest of the two lectures. I would miss the participants, but my presence is required elsewhere, so I beg for permission to leave. Thank you.
Thank you, my lord. I now request Ms. Madhavi Guradia Divan, learned Additional Solicitor General of India, to kindly deliver her lecture.
Thank you, Vikrant. I think I'm the one who feels very dwarfed in present company. Justice Sikri, Mr. Venugopal, learned Attorney General, Mr. Datar. It's a great privilege to be here speaking with this very august panel, and to my fellow members of the SCBA. In his book, The Indian Constitution, Cornerstone of a Nation, Granville Austin describes the build-up to the framing of the chapter on directive principles. It seems that while there was general acclaim for the directive principles, criticism came from some quarters, largely because the directive principles were to be non-justiciable. One prominent member, T.T. Krishnamachari, was particularly acerbic when he dismissed the directive principles as, and I quote, a veritable dustbin of sentiment, unquote. The feeling was that the moral but unenforceable charter of aspirations would have little meaning beyond the sentimental. But it is interesting how over the last 70 years or thereabouts, how what was dismissed as a dustbin of sentiment has guided the legislative as well as the judicial narrative in ways both spoken and unspoken. What is interesting is that the very non-justiciability of directive principles, the very criticism mounted against their inclusion in the Constitution at the time, has lent these principles a certain inherent dynamism and elasticity, a dynamism which has been put to good use by our courts to creatively carve out rights not expressly spelt out. Directive principles have been drawn on to endow fundamental rights with new dynamic interpretations demanded by changing times. Pandit Jawaharlal Nehru compared directive principles with fundamental rights, and he said he recognized that directive principles represent a dynamic move towards a certain objective. The fundamental rights, on the other hand, represent something static and preserve certain rights which already exist. That dynamism then, perhaps a facet of their non-justiciability, has become an advantage rather than a disadvantage. Fundamental rights and directive principles represent symbiotic parts of a larger organic whole. 70 years or thereabouts of working the Constitution has shown how fundamental rights have drawn from directive principles and how the two supplement and complement one another. In Minerva Mills versus the Union of India, the Supreme Court observed, and I quote, "The Indian Constitution is founded on the bedrock of the balance between parts 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. Fundamental rights are not an end in themselves, but are the means to the end specified in Part 4, unquote. While the topic for today's lecture is the role of directive principles in enforcement of fundamental rights, the object might have been a little different. Directive principles represent the vision, and the object, fundamental rights, are only the means. The social revolution envisioned by we the people of India comes through with far greater clarity in the directive principles than in the fundamental rights chapter. The fundamental rights in chapter 3 contain broadly negative injunctions against the state, preventing it from interfering with the liberties of citizens. Granville Austin describes fundamental rights as those negative obligations of the state not to encroach on individual liberty. The directive principles, on the other hand, seek to liberate the Indian people in the positive sense, freeing them from centuries of coercion and oppression, from physical exploitation that held them back from self-realization. The directive principles are a moral charter, a set of moral precepts representing humanitarian and socialist aspirations. They can be traced back to the streams of socialist and nationalist sentiment in India that inspired and sustained the independence movement. The government was regarded as the flag bearer of change. It had to bear the responsibility of improving the lot of the teeming masses of Indians and to establish a welfare state. In the past, whether under the Mughal rule or under the British Raj, the people generally looked to the ruler for dispensations, both good and bad. What the government did not do or did not get done was simply not done. That sentiment was carried forward by the Constituent Assembly, which believed that the onus to bring about a social and economic revolution continued to rest with the government. Even though the directive principles were not made justiciable, they are nonetheless, as Article 37 acknowledges, fundamental in the governance of the country, inasmuch as it shall be the duty of the state to apply these principles in making laws. These principles are an expression of hope that certain national, social, and economic priorities will be fulfilled. They act as the guiding spirit, the lodestar that steers the course of legislative and often judicial action. There is a wide gamut of aspirations in the directive principles on a range of varied subjects. Given the constraints of time, I am going to broadly pick on only one of those sentiments expressed in the directive principles and see how much progress we have made in the enforcement of fundamental rights through what is stated in the directive principles. 70 years ago, the framers of our Constitution laid a great deal of emphasis on securing equality and equal opportunity for women in the workplace. I am particularly struck by the emphasis laid so many decades ago on the rights of women in the workplace and their importance in the workplace. Reference is made to securing the right to an adequate means of livelihood for men and women equally, equal pay for equal work, the health and strength of workers, including women, and maternity relief. A great deal of care and thought seems to have gone into these sentiments. The aspirations charted out 7 decades ago are nothing short of being visionary. The framers of our Constitution realized the importance of ensuring that the other half of our population contributed to the workforce, not only to afford women the opportunities for fulfillment and self-reliance, but also to ensure that society could benefit from the invaluable contribution and talent that women can make to building the economy and to society. 70 years and many laws and judgments later, we are still struggling for attainment of some of those very basic goals. Article 39A, which provides that the state shall direct its policy towards securing for citizens, both men and women equally, adequate means of livelihood. Means of livelihood can mean a myriad different things: equality in eligibility for both men and women for certain kinds of jobs, level playing field at the entry level. So we had judgments, path-breaking judgments like Anuj Garg, which tried to shake up patriarchal norms to say that women too could work as bartenders, and their choices and opportunities cannot be stifled by citing their safety as an excuse. That judgment struck a blow at what was described as romantic paternalism. We had before that Nargish Mirza, which allowed for women air hostesses to retire at par with male colleagues. Later came Charu Khurana, which opened up more professional opportunities for women. But Article 39A, I would reckon, is even deeper than that. It means providing working conditions which make it possible for women to stay the course. Women, despite being qualified, despite flying over the fences when it comes to examination results, somehow drop out of the race over time. Why does that happen? Because of a working environment which does not make allowances for family responsibilities, for maternity care, which means that women must opt out of the race only when they are starting to make their mark. In many mainstream professions such as our own, it could not be a mere coincidence that while only a handful of women are able to bubble up to the top, if at all, women with families to raise rarely, ever so rarely make it. Creating an environment where all, including women with families, can flourish, I believe, was a strong visionary sentiment expressed in the directive principles so many decades ago. After all these years, workplaces, including our court, have begun to take baby steps in that direction, and the setting up of a creche is one of those baby steps. An adequate means of livelihood also means freedom from a hostile working environment where women till not so long ago had no means to complain of sexual harassment. This is fortified by Article 42, which provides for just and humane conditions of work. That means a safe working environment and protection against unwanted advances. Vishaka filled in the vacuum where legislation was lacking. Perhaps Vishaka relied on international treaties and not our very own directive principles, but really this judgment was an effectuation of those just and humane working conditions that Article 42 refers to. Vishaka eventually goaded legislation, so what was non-justiciable became justiciable. Therefore, there has been a move from a welfare-based approach to a rights-based approach. Fundamental rights were once described by the Supreme Court as empty vessels into which each generation must pour its content in light of its own experience. Much of that content was drawn consciously or otherwise from the directive principles. Much of what was non-justiciable became justiciable by infusing fundamental rights with the sentiment of the directive principles. Those empty vessels then are now brimming with much of what the directive principles gave us. Thank you very much.
Thank you very much, ma'am. Now I request Mr. K.K. Venugopal, Learned Attorney General for India, to kindly deliver his lecture.
Justice Sikri, my friends on the dais, and in the audience. I should congratulate the Supreme Court Bar Association for having reintroduced this series of lectures, which I find from the attendance here is something which the members of the bar themselves welcome. Now the topic is on directive principles, and the directive principles were originally put into the Constitution not as enforceable rights, but to supplement the fundamental rights for the reason that social justice was required, economic welfare, and foreign policy and legal and administrative matters had to be dealt with. This could not be put into the fundamental rights, and I will explain in a few seconds or few minutes as to why that was so. And therefore, the directive principles ended with a caution that so far as these are concerned, these are not enforceable. But nevertheless, the state shall keep these in mind in implementing laws. And when they make laws, the directive principles were to be injected into those laws. They are to be kept in mind. Now, the reason why, according to me, these are put as directive principles and not as rights or fundamental rights is that we are still a developing country. And for a developing country to guarantee or promise to the people that they will all be entitled to have jobs, that they'll all be entitled as of right to have 100% education and free education, say up till 14 years, as a right which could be enforced in a court of law, that they shall have shelter and houses over their heads. And therefore, in those circumstances, these are dreams so far as a developing country was concerned. And it's only with the evolution of time, as a country developed, that one by one, if you felt that your economic conditions would be able to take in the enforcement of these rights, they could be given. But the result was that a number of judgments of the courts sought to use the directive principles for the purpose of enforcing rights. And therefore, they were elevated to a certain extent. And this is what was said in 1986 at Atma Prakash's case. It was held whether it be the Constitution, this is a court, that is expounded, or the constitutional validity of a statute that is considered. A cardinal rule is to look to the preamble of the Constitution or as a guiding light and to the directive principles of state policy as a book of interpretation. The preamble embodies and expresses the hopes and aspirations of the people. Directive principles set out proximate goals. Therefore, you find that, for example, prohibition was upheld in many states by using the directive principles which said that there shall be a prohibition of the consumption of alcohol. Slaughter of cows was prohibited by relying upon Article 48 of the directive principles. That is in Qureshi's case. Right to education was enforced by using Article 45 of the Constitution. And as all of you know, that was finally transcribed into the Constitution itself as a fundamental right under Article 21A. Now, these are the great achievements in the early years, and I would stress the fact that in the early years, these directive principles had to be brought to aid. That is because judicial activism had not reared its head in a very conspicuous way. But once the court became a very proactive judicial body, then we found that there was a total difference. Article 21. Now that merely said that so far as no person shall be deprived of his life or liberty other than by the procedure established by law. Nothing more than that. But what is his right to life? I would say it may be in contrast to death. Therefore you shall not be subjected to death, or you shall not be deprived of your life other than by the procedure established by law. But the Supreme Court in its wisdom, and I say rightly, was able to breathe life as it were into life in Article 21. And what they held was, they read into Article 21 the right to legal aid, the right to go abroad, the right to reputation, the right to shelter, the right to privacy, the right against sexual harassment of women, the right to education, and the right to a clean and healthy environment. Now, many of these you will find are reflected in some aspect or other in the directive principles. Now, if that be so, one would ask, why is it necessary to have directive principles? If the founding fathers had known that so far as the Supreme Court of India was concerned, it was going to be a very proactive court, and so far as this proactive court is concerned, it was in a position to read so many rights into Article 21, so that the directive principles were practically effaced. Added to that was Article 142 of the Constitution. Now, the significant aspect of Article 142 is, it doesn't refer to any particular topic which has to be dealt with by the court. Therefore, so far as 142 was concerned, it was used for the purpose of passing any particular judgment, expanding the scope of the judicial power for the purpose of intervening in any matter. There is no matter which is outside the purview of Article 142. And therefore you found that so far as the pricing of drugs is concerned, so far as the regulation of mines and minerals are concerned, so far as the sale of liquor on next to the national highways are concerned, the Supreme Court dealt with each one of them and expanded it. Therefore, with a combination of Article 21 and Article 142, I say that so far as the directive principle of state policy is concerned, it did not become necessary to invoke any one of those directive principles because the court had armed itself with tremendous powers. Now, I was in the government of Bhutan had consulted me in regard to their constitution, and the constitutional drafting committee headed by the Chief Justice had met me, and when I saw their constitution draft, I was surprised to find that all that we find as directive principles including housing, including shelter, including medical facilities, including jobs, etc., were all as fundamental rights in the rights chapter. There is no directive principles. Therefore, and over and above that, Article 7 of the Bhutan Draft Constitution said that each one of these rights will be enforceable through a petition to be filed before the Supreme Court of India, similar to our Article 32. For I asked the Chief Justice, in case the citizens as a group come before you as Chief Justice of Bhutan and file a petition saying that each one of us has to have a house, and we don't have a house, we don't have shelter, we don't have medical facilities, we don't have jobs, what do? Are you going to issue a mandamus to the state to give all of them? Therefore, what we would realize from this is, it is all subject to the economic and other competence of the government that you would give all this. Therefore, he carved out many of these articles, which are supposed to be rights. They called it sections. Article and then 20 sections under each article. They took out all these articles, which related to what would rightly be directive principles, not enforceable directly by the court, and put it separately and called it they called it not directive principles, but they said principles of state policy. Now, with that, of course, they protected themselves. It was only during if the state became so powerful economically and otherwise, that it would be able to extend all this. We have 170 million people living below the poverty line. They do not live, they live in perhaps subhuman conditions even. Are we in a position to give them all the benefits which Article 21 had granted to them? I say no. Then what's the purpose of declaring these rights if you are not in a position to enforce it? Because I declare a right but I don't enforce it, and therefore the court has to enforce it, but it cannot, because it depends upon the economic conditions of the state. And therefore, in those circumstances, I would think that the directive principles rightly was able to say that so far as these are concerned, it is within the economic, subject to the economic means of the state. You shall do this, you shall do that. Therefore, if your economic condition did not permit it, you shall not do it. And therefore, that was the directive principles. And that is what you have to necessarily say when you declare all these rights under Article 21 of the Constitution. But it stands there, I have all those rights, they have been declared, but they cannot be possibly enforced, because unless a state becomes over the course of years, we become a developed country. And if we become a developed country, we have the means, and we'll certainly give it to them. Lastly, I would ask myself this question: what is the purpose of all this? Because assume that the directive principles are not there. Article 21 was not interpreted in this fashion. 142 was not there. Would you not still have to see the state that so far as every citizen is concerned, he does not lead a mere animal existence, but that he lives with human dignity, and that is what the Supreme Court had said. And therefore he should have the basic means, the wherewithal with which he could live a decent life. The Constitution is silent, but nevertheless it's a duty of a state. And I say therefore, so far as this is concerned, whether it's the directive principles or Article 21 or Article 142, so far as the state is concerned, it is the bounden duty not to make false promises in your manifestos, but I think the entire priority has to be to the poor people of this country and not to the rich who access the courts. Thank you.
Thank you, sir. For second topic, that is economic perspective in law, I request Honorable Mr. Justice A.K. Sikri to kindly deliver his lecture.
Thank you very much, and Mr. Yadav, and good afternoon to all of you. Mr. Venugopal, the Attorney General for India, Mr. Rakesh Khanna, President, Supreme Court Bar Association, Mr. Yadav, Mr. Sharma, our very, I would say, a new face and very welcome face insofar as law officers are concerned. ASG Divan, and Mr. Datar, who is expert in all fields. I was thinking that when this topic of directive principles was discussed and these lectures were delivered, Mr. Uh, Datar must be thinking that, oh, this is my topic as well. But he is expert in the topic which we are going to address. So therefore he'll be equally at ease, I know. Let me at the outset thank Mr. Rakesh Khanna for giving me this opportunity. And what a coincidence that as far as officially in my present capacity, this is going to be my last lecture. And he very much wanted about a month ago, I think we had discussed, but somehow the things got delayed. But at least and at last we are here. As he said that I chose the topic on this law and economics when he said that you should give a lecture after Chief Justice gives, because it was initially designed that first week he will give and next week I'll give. But then last week I think it couldn't happen, and that is why these two programs are consolidated. Yes, in the process suggested this topic because I was thinking that this is one area where subconsciously in decision making, economic factors are seen by the judges or are impressed upon and argued by the lawyers, but there is no direct discussion on this aspect and conscious effort as to how the economics can play a role in decision making. Let me tell you, it is not something which is totally new. Yes, it may be new insofar as this country is concerned. But if you talk about, the word scenario, it was way back in 1850s, Adam Smith and David Hume, they conflated the law and economics in their works. And Bentham also had talked about it. But then thereafter, for many, many decades or maybe a century, it remained dormant in almost all jurisdictions. It was in 20th century and after 1950s, or particularly after 1970s and 80s, that it surfaced in this kind of approach, economic approach or approach of economic analysis while deciding the cases in US. And the persons, the scholars who were economists as well were Ronald Coase, Frederick Hare, Gary Becker, and there are some legal scholars like Caleb Aresi. They have written tremendous amount of work. Much of this I have read as well, including one Court of Appeal judge, Judge Richard Posner, who demitted office a few years ago, and he remained judge of the court in US courts for almost 35 years. And Coase and Becker, let me tell you, they were even awarded Nobel Prize for their respective works. Now, this mainly the idea thrived and when the Posner had written so many books on this. If you see, whenever we, in our jurisprudence, as students we have studied, and in courts every day, when we talk about the interpretation of statutes, or interpretation of various provisions of constitution also, and various jurisprudential theories of justice and other theories as well, we would normally we'll talk about law and morality, we'll talk about this theological or philosophical approaches to law and how these should be interpreted. But there has not been much up to now insofar as relevance of field of economics in law is concerned. And here they have, all these scholars, I mentioned these names, they have talked about the economic aspects of law as well. Now, the first question, therefore, in this scenario is, what is law and economics? Or what is the relationship between law and economics? Or what is, if I phrase it more appropriately, what would be the economic analysis of law? And as the name indicates, a theoretical analysis of law based on principles of economics. The overarching principle being efficiency and rational choice theory. Now, this is the theory which is much prevalent in economics. Those who are the students of economics, I am, and they would be knowing about it. So, in that context, it examines legal rules as a set of incentives aimed at bringing about the desired social interest. So these are the economic rules which are brought, and in that sense, if you see here, in the economics, it is said, and the presumption is what we call that every person is a rational person, and whenever some choice is given to take a decision in economics per se, it will be a rational choice, depending upon what is in my favor and what should I do. Even if you go to market and you want to buy a particular product, you will see various brands of that particular product. You will see what is the quality of that product and what is the price attached to that. Naturally, you may pay even a higher price, but if you feel that the quality is better. But you will always try to get better quality product with as less possible, by bargaining, etc., as you can. So this is what rational choice is, in nutshell, if I tell you. And so this is, choice is based that, and the economic analysis or economic theory says, to maximize the individual satisfaction. And from this follows the other theory, which is the counterpart of it, and this is called social efficiency. And the social efficiencies is the economic state where there is an optimal distribution or allocation of resources, minimizing waste and increasing the net value of resources. That is what the consideration would be with every person who wants to set up a business or every person who wants to set up industry. And this, I'm just now telling about these basic economic principles, and how when you apply such principles in decision making, and in the process you think of the maximum individual satisfaction or societal satisfaction, that particular kind of outcome, and that is, we are introducing here now the element of economics into the law, if in a particular given case we do that. And for this purpose, actually this analysis can be of two types, as the scholars have said, and depending upon the questions which we need to address in a particular case. On the one hand, a descriptive analysis of legal rules which deal with the effect of legal rules on relevant social actors, and is used for explaining and predicting how people act under various legal constraints. We know that. Actually, there's a very interesting book. It is called Freakonomics. And yes, Freakonomics by this Edwin. Let me tell you his full name. It is Stephen Levitt and Stephen Busner, two authors they have written. And a very interesting theory which they have developed is that all crimes which take place, again we are talking about law and criminal law here, all crimes which take place in the society have economic factors behind it. And they have analyzed in the entire book, and therefore they have said, if we keep in mind the economic factors and we try to eliminate those, there would be no crime. And the authors, I had read this book about 10, 15 years ago, but they have come out with another second edition also. It's not second edition, rather another volume also on this book, which is called Super Freakonomics. And in that book, if you see, the manner in which they have tried to, it's not that it's only a theoretical discussion in the book. They have even tried to demonstrate in America by taking particular projects, when these were the situations, what was the crime rate and how it came down. And it's very interesting. Because of paucity of time, I won't be able to go into all this. But then, when we talk that this is the economic analysis and how it is to be done, of course, let me now try to tell you in somewhat easy words or in easy manner, in the context as to what is the role of judge and how the judge are supposed to apply these principles. As the last topic itself shows, that India is a constitutional welfare state. We have been talking about this welfare. And one of our most important social goal is the social welfare. So since our country is en road of economic growth, economic welfare and well-being of the citizens, especially the most vulnerable sections of the society, is an indispensable part of social welfare. All the wings of the state, the legislature, the executive and judiciary, should therefore take measures to ensure that this goal is achieved. The legal regime in our country is already moving in that direction. If some of the recent laws, and when we talk of ease of doing business as well, are, if you see, insolvency and bankruptcy code, they entirely based on economic considerations, even real estate regulation and development act, and the constitutional amendments which are incorporated to bring about Goods and Services Act. There's, at the back of this, there are total economic considerations. And in one of the judgments in Shiv Shakti Sugar Limited, the Supreme Court had said so while applying this principle of law and economics, that the judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in economic growth. It calls for an economic analysis of law approach, most commonly referred to as law and economics. The first duty of the court is to decide the case by applying these statutory provisions. We have to, because we have to decide the case as per law. However, on the application of law and while interpreting a particular provision, economic impact or effect of a decision, wherever warranted, has to be kept in mind. Likewise, in a situation where two views are possible or wherever there is a discretion given to the court by law, the court needs to lean in favor of a particular view which subserves the economic interest of the nation. Conversely, the court needs to avoid that particular outcome which has a potential to create an adverse effect on employment, growth of infrastructure, or economy, or the revenue of the state. Now, take for an example, and it was said way back in Ronak International judgment as well, in the context of when the public project which is coming up and a PIL is filed, or even a tender which is awarded and the award of tender is challenged, and the stay of the project in the meantime is sought. Whether the court should grant that stay at that time or not, and in that case also, the division bench said that, look, although may not be, as I said, subconsciously these considerations are kept in mind, that if the project is stopped today, and if after 1 year or 2 years the petition is dismissed, what is going to be the impact of this public project insofar as economic considerations are concerned? If suppose the project is worth 1,000 crores today, and after 2 years or 5 years, the cost may escalate to 2,000 crores or 1,500 crores. So therefore, whether today we should grant that stay, that these are the economic considerations which come in mind and which have to be kept in mind. Yes, as I said, that in the first instance, statutory provisions are to be kept in mind. Suppose in a particular case it is found that the basic procedure was not followed at all. Suppose take an extreme case where the contract is awarded without even inviting tenders, and that is not followed. Yes, then the court may not look into those consequences. But if it's a tribal issue which the court has to go into, and the procedure is followed, and the court has to scan through it whether it is right or wrong, but in the meantime, what steps should be taken? So this is the economic consideration which come into mind. I give you the example of, it can be in various laws. I tell you, I have a very detailed paper.
I will not be able to say everything. I'll give the paper to Mr. Khanna. It can be circulated or put on your website. But take the example of Land Acquisition Act. Now, why new act in 2013 was enacted? Because we saw under the old act, whenever land is acquired, whether fair and reasonable compensation is given or not, that is the economic aspect, because the person who is divested of his land wants full compensation or adequate compensation so that he is able to buy some other property if he is divested of his agricultural land or maybe house property, etc., whatever. So, but why it led to the litigation is that every time the person whose land is taken away would think that they are not adequately compensated. So therefore, this new act of fair compensation, and if at that stage, what is realized now is that you enter into an agreement or tell him and take his consent and then take over the this land, there may not be much litigation or much problem in this. IBC, I have given the example how it is explained. Even competition law is entirely based on economic analysis. But take, for example, intellectual property matters. Now, when intellectual property matters come, suppose it's a matter relating to infringement of trademark, and a suit is filed, where plaintiff says that defendant has infringed his trademark. There may be a clear case of counterfeiting, that I am putting a label of Calvin Klein and therefore selling under the name of Calvin Klein, which I can't. So there can be an injunction straight away. But question is whether I have copied the design or this trademark is deceptively similar, etc., and there is a genuine dispute. Now here the question comes whether when the suit is pending and it is still ultimately finally decided whether there should be an injunction, a temporary injunction or not. Here, when we talk of balance of convenience or prima facie case or irreparable injury, according to me, complete principles, economic principles have to be applied. One case came before me when I was in the High Court of Delhi. It was a case under Designs Act. Pearl Pet, you know, is a very famous with their bottles, etc., and they had filed the case. The defendant was saying that I have not copied the design, but it was again a genuine serious dispute whether he has done it or he has not done it. What ultimately, after analyzing that, prevailed in my mind, which I had written in that order also in the High Court. Look, here defendant is not a fly-by-night company. It was having its industrial setup, a big industrial setup with maybe 150 to 200 persons who are employed there. He had invested 15 to 20 crores in that project. Now the question is, if you grant injunction today, then what happens? Not only he had taken loans from the bank, so not only he will not be able to service the debt, 150 persons would get unemployed. As against that, if ultimately plaintiff succeeds, then plaintiff can always be compensated in terms of money. So therefore, these economic factors even in IPR laws would come. Another very interesting thing, and then I'll stop at that, because as I said, there are so many other things I'll give, that even, you see, when we talk of economics, from litigants' point of view, I'm not talking about the access to justice, of totally different aspect on which I am going to write in near future. I'll get time also now. This is an aspect of mediation, that there is an economic element behind it. When a person is to choose his remedy, that what kind of suit he should file, the advocates think there may be a case where there may be some element of criminality. So they'll file that criminal case against the person instead of filing a civil suit for recovery. They may file a suit of cheating, etc. Going by these considerations, I may not have to spend much money. At the same time, there would be more pressure on the other side, and I may get my money immediately. These are economic considerations. But then the best economic consideration to advance mediation is that it is the least cost bearing. That has to be propagated, and that is why people may be going, and in many statutes now, this is becoming a provision is made, and it is made compulsory, this mediation. So even in behind the success story of mediation, there may be this, if we adopt the economic principles, it may bring desired results. There are certain exceptions to the economic analysis of law. As I said, that it depends upon altruistic behavior, it depends upon the rational behavior of a person. But then there are certain persons in this society which go by altruistic considerations. They may not go by economic considerations. And therefore, now take for example, this education, healthcare. Then in these cases, whether it is one can go by total economics, I think it may not be. Take the example which comes to my mind is in the case case of patents, that Navratri's case, where life-saving drugs which are required. Now, court has to keep in mind the interest of the person, the patients who have to get these life-saving drugs at cheap rates. And that was in the mind of the court, I feel so, although it is not so stated, but one can easily make out. It was in the mind of at the back of the mind of the court that, look, if we protect this patent of a multinational company, drugs in this country may be much, much costlier, which our people may not be able to afford. So while interpreting Section 3D, the court, interpreted in such a way so that no harm comes. Here what I'm trying to say is that sometimes, insofar as human rights aspects are concerned, there may be some conflict between the economic considerations on the one hand and human rights. Take, for example, environmental laws. Now, many industries are banned. It was in 90s and 2000, early 2000, Supreme Court banned many entries in scheduled entries in Delhi. But then one could say that, look, it has adverse economic effect. Production goes, unemployment increases, etc. But in the interest of the health of the people, this had to be done. But very interesting case came before me, which I can say, and Mr. Datar has also been appearing in that case of firecrackers. Now, here it was argued that, look, many would be affected. Here I am talking of that particular, and I'll give one or two examples on that, and for you to decide, where the effect of that particular, the environmental effect, it is not necessary that it is because of that particular item only. As it was argued, that look, if air is polluted in Delhi or elsewhere, it is the firecracker is not the sole cause, which is correct. Now here, but it contributes. This is also correct. The question is, on the one hand, we have, yes, 5,000 crore industry in Tamil Nadu. There are thousands of people employed there, is on the one hand. But then, as against that, if there are ill effects on health of those persons, if it is polluting the air, what is the cost of health? Here there is no data. I indicated in my order and left it at that. So economic analysis, while working out this, there are three elements which come. Human rights on the one hand, then employment and the rights of the industry, and on the other hand, and cost of health on the other hand. All these have to be worked out. That's why I said I indicated and left it that, because in the absence of any statistics, you could not do so. Another case which came before and which has been subject to some criticism is this on highways, these liquor shops. Now question is, on the one hand, we are this banning those liquor shops, because what is the interest involved as per the court? That many road accidents take place when the drivers drive under the influence of liquor. But question is, when we take up economic analysis, because will by banning it, you are naturally stopping, or you are, closing so much of shops, etc. there, and unemployment, earning of those people is one economic factor. On the other hand, what I feel is the study should be done, how many accidents take place because of that reason. If that's the sole reason, yes, human rights would prevail. But if that is not the sole reason, then how many accidents take place because of that reason? This is the study which has to be undertaken. Another example I give, when for environment, 2000 CCC cars above 2000 were banned. Now again the dispute was, and it was argued by the car manufacturers, that the pollution to the air because of this 2000 plus cc cars is minimal, or there's hardly any, point something. So therefore, on the one hand, if it is not making a major contribution, can you ban the this production and sale of the cars, not production, at least sale of the car in this city, only because of this reason, which may have economic factors? So there's any number of examples of this nature, and I feel that it is high time now the courts should take into consideration the comparative analysis from economic point of view, and on that basis these cases should be decided. Thank you very much.
Thank you, my lord. Now I request Mr. Arvind P.Datar, Senior Advocate, to kindly give his lecture.
Good afternoon, Honorable Justice Sikri, Mr. Khanna, Mr. Yadav, Mr. Sharma, my colleague Madhavi Divan, and my dear friends who have stayed on well beyond 2 o'clock. I will not take much time. On a miscellaneous day to listen to law beyond 2:20 is really violation of Article 21. Incidentally, I'll just make, with the permission of Justice Sikri, I'll just mention one more thing. We had a unique privilege of Mr. K.K. Venugopal being present here. I would just like to tell the younger members of the audience that if you see Minerva Mills, AR 80 Supreme Court, page 1789, Mr. K.K. Venugopal was the Additional Solicitor General who argued the case. And Mr. Palkhiwala appeared for the petitioner. And the other interesting information is Mr. Palkhiwala's junior in Minerva Mills was none other than Justice Rohinton Nariman. So this is the part. Now, coming to this economic perspective, you see, as far as, I'm just going to be brief, just about 10 minutes. In terms of lawmaking, you have lawmaking at the legislative level, at the executive level, and at the judiciary. At the executive level, very briefly, till the 60s, you had a completely bipolar world. You had one set of countries following the capitalist doctrine laid down by Adam Smith and so on. You had the communist countries following the Karl Marx doctrine. Over the years, all those things diluted, and today we have what to call the neoclassical theory, which is an amalgam of right wing and left wing. Your right wing represented the followers of Adam Smith down to Milton Friedman, and on the left wing you have people like Joseph Stiglitz, and a combination of those is the middle order of the country. But I'm not concerned with that. I'm also not talking of the executive, the regulators. If you take every regulated industry, SEBI, electricity, TRAI, all these cases, economics plays a very, very important factor. But due to shortage of time, I'm just going to confine myself to one important judgment delivered by Justice Sikri in 2017, that is Shiv Shakti Sugars versus Renuka Sugars, where the Supreme Court laid down, and they used the word bounden duty. They said it's the bounden duty of the courts to consider the economic impact and the economic analysis of a particular judgment. This is particularly important in India because you have Article 142, you have Article 226, where the High Courts and the Supreme Court can simply stop an industry at the interlocutory stage or at the final stage. Now, the consequences of this can be quite horrendous. Justice Sikri mentioned the liquor ban, with which I was concerned. I was appearing for all the liquor people from Tamil Nadu. Now, on the 30th of April, by straight one order, all liquor shops on highways throughout India were shut by one single order. Look at the consequence. Well-intentioned order. The matter came from Punjab. They said in Punjab, for every 100 kilometers, there are some 125 liquor shops. And therefore, as Justice Sikri pointed out, was there a causal link between highway liquor shops and accidents? According to us, the statistics showed that only 6.81% of the accidents were due to this. But the Supreme Court felt otherwise. We respect that. But look at the economic consequences. According to Government of India statistics, by that particular decision, 26,800 shops all over India on the highway were shut. 1 lakh people lost jobs directly. The loss of excise revenue was simply staggering. Now, following Justice Sikri's judgment, the court could have had an economic analysis. How much of liquor shops, how many are there on the highways? What is the quantum sold? Why are we banning hotels and bars situated in the cities? Because in many cities, the main roads are declared as state highways. So all hotels in next to that was closed. In Madras, for example, from where I come, except Taj Coromandel, all 5-star hotels were closed, and Taj was not shut because it was 620 meters from the highway and that escaped. And just one instance at 2 o'clock, so I thought just give an interesting example of how people get over the liquor ban. A person went to Pune to a 5-star hotel and went to the bar on the ground floor and asked for a drink in the evening. They said, we can't serve you liquor on the ground floor. But this is a 5-star hotel by one of the reputed companies. But they said, if you go to the 7th floor, there's an Indian restaurant, we serve liquor there. So I asked him, how do you do this? So he said, if you take 500 meters and count the steps, we cross 500 meters on the 7th floor. And gentlemen, this story is true because I was that guest. Now, so I felt that economic analysis they could have done. As far as diesel ban is concerned, I had the occasion to appear for Mercedes-Benz in that diesel occasion. Now you ban it overnight. There's no difficulty. You've got the power to do it. But what are the economic consequences? Now all these companies plan their point 5 years, 6 years in advance. They go by the basis of BS4, BS5, BS6. Their vehicles are legally compliant. And as I mentioned in one judicial academy where Justice Sikri also was present, I said India has a very, very strange paradox where what is legally permissible becomes judicially impermissible. And that can never be done. So the first principle is that when we decide to get into economic consequences, we should first understand is what is being done statutorily valid. If that is the case, then there should be no interference. Apart from liquor and this diesel, Justice Sikri mentioned firecrackers. Yes, it is a serious problem. No doubt the pollution in Delhi is horrendous. I fortunately come from Madras and Bombay where the seashore is there and they are the lungs of the nature, and we don't have this kind of pollution which we have here. But at the same time, now the Supreme Court has to balance it. There's a concept which Justice Sikri has said about green crackers. Can we have firecrackers? We don't want to spoil the Diwali fun, but we do it with a responsible way. We have green crackers where the barium nitrate content is low. Because at stake are 7 lakh jobs in Tamil Nadu. You take any Tamil news channel today, there are news item after news item, people coming on the streets because of jobs and so on and so forth. But at the same time, if it is going to be noxious and harmful to health, then there is no justification for that to country. Is there a balancing interest? Other most very, very devastating effect was the mining orders, the ban on coal and ban on so on and so forth. I know cases where people have started a power project based on a coal allocation. They have taken loans. They have entered into power purchase agreement with the government. Now overnight you ban the coal allocation. Your power purchase goes for a toss. Your entire industry is shut down. And there is simply no recourse because if it's an executive order, you can challenge it, but if it's a judicial order, there is no remedy at all. And I felt that Justice Sikri's judgment in the Renuka Sugars came in May 2017. And at that time I had felt it came in the summer. And I felt that if this judgment had come 2 years earlier, maybe the courts in the liquor case or the diesel case or the mining case would have said, should I shut down all the mines? Should I cancel all the coal allocation? Can I say that everybody should pay 294 from 1994? What is the economic impact? Can the industry sustain it? All these factors would have been taken into account, and perhaps perhaps the orders would have been different. Now, Justice Sikri mentioned about Richard Posner and so on. Those of you who are interested, all the foreign literature, I find that they discuss the impact of economics on law, but there is no literature on examining the economic consequences of a judgment. Because perhaps they don't have Article 142, they don't have, I mean, I can't imagine the UK Supreme Court saying diesel vehicles should not be there. That can't be done. But India, it is possible. So in India, we've got a unique feature where hereafter, we must consider the economic consequences. There is a lovely article, those who are interested, the summary of this thing is in Richard Posner's article in the Texas Law Review. If you want, it is 1975, 53 Texas Law Review, page 757. You go to the University of Chicago website, that article is easily available for downloading. It's 20 pages, it summarizes all the law. You can read that. Other point you must raise in this context is Professor Lon Fuller's article in the Harvard Law Review, where he says where judiciary should not interfere or should be very careful. And he calls it polycentric disputes. Take liquor. It's not just the liquor, it's the liquor shops, it's the hotels, it's the bars, it's the employment, it's tourism, tax revenue, all these are things. So he says these multiple factors are like the strands of a spider's web. You touch or put too much pressure on that, the whole web will snap. And he says that these are not concerns which are meant for adjudication by the courts, because the courts can't, in a case, listen to all the stakeholders, and these are best left to the legislature. But in our system, I would submit that if the courts really want to get into this question of banning, say, firecrackers or diesel or alcohol, then it is better to hear all the stakeholders. In Environment Protection Act, you got environmental impact assessment. So I would canvass that, as Justice Sikri has put it in his judgment, that after Ronak, the next judgment is Renuka Sugars. But there are some stray observations of economic analysis, stray observations saying court should not get into these areas. But there is no consistent, coherent body of law as to what should be the study undertaken in deciding the economic consequences of a particular judgment. And I would submit just shortly that, see, is it a state problem or a national problem? If liquor was a problem in Punjab, is that the problem all over India? Not necessary. Can you put a 500-meter ban in a state like Kerala, which is narrow? It's not possible. So see what is the impact in your particular judgment. What is the consequence on employment? What is the consequence of revenue collection? What's the consequence on environment? So ladies and gentlemen, Justice Sikri's judgment for the first time says there's a duty cast upon the courts to consider the economic impact and economic analysis of their decisions. Maybe this seed sown by Justice Sikri should grow into a tree, and we should have soon a coherent body of the law. Thank you very, very much.
Thank you, sir. Now I request Mr. Jiten Mohan Sharma, Vice President, Supreme Court Bar Association, to give vote of thanks.
Justice A.K. Sikri, Madhavi, Divan, Mr. Arvind, my friends, the endeavor of SCBA to have a lecture series, and on behalf of whole executive committee, I thank the speakers. We had, they found a time, in fact, because of some constraints, we had to combine 2 lectures in one series, and I thank all speakers, those who were there. Thanks for the Honorable Chief Justice, who has given us the details of stating that the directive principles, the interpretation of fundamental rights, while enforcing fundamental rights. We had a very interesting interpretation given by Justice Sikri, stating about the economic aspect, what would be consideration would be there while interpreting a law. And in the end of it, I thank all of you to be here at, it's almost 2:30. Thank you very much. Thank you very much for being there. Thank you.
you.